So let's talk about the recent changes in Florida law. As of March 24th, 2023, Florida Governor Ron DeSantis signed into law personal injury reform. Now there will be several huge changes to the way we do personal injury law going forward. Contemplated under House Bill 837 is the change from a pure comparative negligence state to a 51% comparative negligence state. What that means is comparative fault means that you compare the fault, or you take the percentage of fault that each party has in the claim and you reduce the general award based on that amount. So prior to this change in the law, if someone was at fault for your injuries, the question usually comes up, well, did you have any liability in it as well? And if you did, whatever percentage the jury determines you were at fault, your award was reduced by that amount. And the other person was able to pay their fair share of fault or liability they had in causing your injuries. Now, if a jury decides that you are 51% at fault, that means that the other party is off the hook and doesn't have to pay anything for the injuries they've caused you. Now, this may not seem so great of a deal, but what it does is it has a chilling effect on going to trial in a matter, because some cases are bang bang. They're a toss-up, if you will. And when it comes to a toss-up on a contingency fee based case, an attorney has to have a good sense that they're going to recover on this claim, or else they're out of all of the money that they fronted for the client to keep their case going. That's how we're able to operate on a contingency fee base. Now, more of those questionable cases won't be filed. Guess who gets the windfall? The insurance company, because they no longer have to pay. But guess who really eats the bullet and bites the bullet on these things? The injured party does, the citizen does. And that's exactly what happened in House Bill 837 when they changed it from pure comparative negligence to 51% comparative negligence. I can think of an example of maybe a catastrophic injury, a catastrophic case where someone ends up being a paraplegic. Maybe they are 51% or 75% at fault for their injury, but maybe someone else carried some fault in it as well. Well, that 25% of a case, a claim that's worth $10 million means a lot, because now it being 25% at fault for that would reduce the award to $2.5 million, but that is plenty of money to be able to take care of injuries when you have a life care plan that anticipates that you can't take care of yourself for the rest of your life. But who do those issues fall on? The people, usually Social Security or other issues like that. But that is exactly what happens. The at-fault party, or a person who shares fault, gets to walk away scot-free if the jury determines that that an injured party is more than 50% or 51% or more at fault for their injury. So this is another very important change that's going to change whether or not some lawyers were willing to take your case and really fight for you, because they don't want to end up with a donut hole with zero at the end of the day. And that is a very tough proposition for anyone to deal with. So that's another very important change in House Bill 837 that Florida Governor Ron DeSantis passed into law just recently as of March 24th, 2023.